Right to assemble and petition, come in petition by Zhang Yinao and Bert Newborn. The right of the people peaceably to assemble and to petition the government for the redress of grievances protects two distinct rights, assembly and petition. The clause referring to a singular right has led some courts and scholars to assume that it protects only the right to assemble in order to petition the government. But the comma of the word assemble is residue from an early draft that made it clearer the founders' intention to protect two separate rights. For example, debates in the House of Representatives during the adoption of the Bill of Rights linked assembly to the arrest and the trial of William Penn for participating in collective religious worship that had nothing to do with petitioning the government. While neither assembly nor petition is synonymous with speech, the modern Supreme Court treats both as some within expansive speech right, often called freedom of expression. Many scholars believe that focusing singularly on expansive ideal of speech undervalues the importance of providing independent protection to the remaining textual First Amendment rights, including assembly and petition, which are designed to serve distinctive ends. Assembly is the only right in the First Amendment that requires more than a lone individual for its exercise. One can speak alone, one can assemble alone. Moreover, while some assemblies occur spontaneously, most do not. For this reason, the assembly right extends to preparatory activity leading up to the physical act of assembling, protections later recognized by the Supreme Court as a distinct right of association, which does not appear in the text of the First Amendment. The right of assembly often involves non-verbal communication, including the message conveyed by the very existence of the group. A demonstration, picket line, or parade conveys more than the words on the placard or the charts of the crowd. Assembly is, moreover, truly free, since it allows individuals to engage in mass communication powered solely by sweat equity. The right to assemble has been a crucial legal and cultural protection for dissenting and unorthodox groups. The Democratic Republican societies, suffragists, abortionists, religious organizations, labor activists, and civil rights groups have all invoked the right to assemble in protest against the prevailing norms. When the Supreme Court extended the right to assembly beyond the federal government to the states, in its unanimous 1937 decision, DeJonge versus Oregon, it recognized that the right to peaceable assembly is a right cognate to those of free speech and the free press. It is equally fundamental. The right to assembly gained particularly prominence in tribute to the Bill of Rights, and the United States entered the Second World War. Eminent 20th century Americans, including Dorothy Thompson, Zachariah Chaffee, Louis Brandeis, John Dewey, Orson Welles, Eleanor Roosevelt, all emphasized the significance of the assembly right. In the time when civil liberties were at the forefront of public consciousness, assembly figured prominently as one of the original four freedoms, along with speech, press, and religion. When, however, President Franklin Delano Roosevelt switched to a different grouping of four freedoms in an effort to rally support for American entry into World War II, assembly and the press dropped out. Neglect of assembly as a free-standing right has continued ever since. In fact, the Supreme Court has not decided a case explicitly on free assembly grounds in over 30 years. But despite its recent state of hibernation, the freedom to assemble peacefully remains integral to what Justice Robert Jackson once called the right to defer. Petition. The right to petition the government for redress of grievances is among the oldest in our legal heritage, dating back 800 years to the Magna Carta and receiving explicit protection in the English Bill of Rights of 1689, long before the American Revolution. Ironically, the modern Supreme Court has all but read the venerable right to petition out of the Bill of Rights, effectively holding that it has been rendered obsolete by expanding free speech clause. As with assembly, however, the right to petition is not simply an afterthought to the free speech clause. The right to petition plays an important role in American history. The Declaration of Independence justified the American Revolution by noting that King George III had repeatedly ignored petitions for redress for the colonists' grievances. Legislatures in the Revolutionary period and long into the 19th century deemed themselves duty-bound to consider and respond to petitions, which could be filed not only by eligible voters, but also by women, slaves, and aliens. John Quincy Adams, after being defeated for the second term as president, was elected to the House of Representatives, where he provoked a near riot on the House floor by presenting petitions from slaves seeking their freedom. The House leadership responded by imposing a gang rule limiting petitions, which was repudiated as unconstitutional by the House in 1844. One of the risks for representative democracy is that elected officials may favor the narrow partisan interest of the most powerful supporters, or choose to advance their own personal interest instead of viewing themselves as the faithful agents of their constituents. A robust right to petition is designed to minimize such risks. By being forced to acknowledge to respond to petitions from ordinary persons, officials become better informed and must openly defend their petitions, enabling voters to pass a more informed judgment. The right to petition should be constructed with a right to instruct. A right of instruction permits a majority of constituents to direct a legislator to vote a particular way, while the right to petition assures merely that a government official must receive arguments from members of the public. The drafters of the Bill of Rights decided not to include the right of instruction in order to encourage the legislator to exercise their best judgment about how to vote. Today, in Congress and in virtually all 50 states legislatures, the right to petition has been reduced to a formality, with petitions routinely entered on the public record, absent any obligation to debate the matters raised or to respond to the petitioners. In a political system where incompetent legislators can make it all but impossible to mount a credible re-election challenge. Energized right to petition might link modern legislators more closely to the entire electorate. The pledge to serve. Some scholars have even argued that the petition clause includes an implied duty to acknowledge, debate, or even vote on issues raised by a petition. The precise role of a robust petition clause in our 21st century democracy cannot be explored. However, until the Supreme Court frees the clause from its current subservience to the free speech clause, matters debate. The first perspective, Beyond Speech and Association, by John Inazo. One of the most troubling developments in modern First Amendment doctrine is the judicial focus on the free speech right to the exclusion of other rights and values and the purposes that underlie them. This neglect has significant consequences for two aspects of the right of assembly: one, the right to protest, and two, the right to associate. Protest. Most protests are governed what is known as the public forum doctrine, which allows the government to regularly express the activities in public spaces through time, place, and manner restrictions. Today's public forum doctrine is linked entirely to the free speech right. The right assembly is seldom even mentioned in judicial analysis of protest restrictions. And current speech-based public forum analysis upholds restrictions on political protesters, anti-abortion demonstrators, labor picketers, churches, and religious groups. The focus on speech to the exclusion of assembly is odd, since the protest is often more obvious assembly, that is, speech, and some protests don't include any verbal expression at all. The origins of the public forum doctrine are closely linked to the right assembly. And the court noted in one of the earliest cases that recognized the public forum, whenever the title of streets and the parks may rest, they have immemorially been held in trust for the use of the public, and the time out of mind have been used for purposes of assembly, communicating thoughts between citizens and discussing public questions. The public forum is a First Amendment doctrine, not a free speech doctrine. Association. The First Amendment refers to the right of the people to assemble. That wording suggests a momentary gathering like a protest or parade. The verb assemble presupposes a noun, assembly, and while other assemblies occur spontaneously, most do not. People usually need to form a group or association of some kind before they assemble in public. Those formative experiences including building relationships, developing ideas, and forming social bonds, activities that ought to be protected from unwarranted government interference. Just as government can effectively eliminate the free speech right by imposing a prior restraint before speech manifests, it can effectively eliminate the assembly right by restricting a group or association before it assembles in public. The Supreme Court has attempted to address these other interests by recognizing a right of association that does not appear in the text of the Constitution. The court initially linked this right to the First Amendment rights of speech and assembly. Over time, however, court scholars neglected assembly roots of the right association and focused increasingly on speech and expression. The clearest example of court's focus on outward expression and the cause for other important values underlying assembly is its recognition of the category of expressive association. In a 1984 decision, Roberts v. United States, JCs. The JC decision also recognized a separate category for intimate association, but the courts have narrowed eligibility for that constitution category to the point that it offers few practical protections. The basic idea of expressive association is that a group is eligible for constitutional protection only to the extent that its purposes and activities further some other First Amendment interests like speech, press, or religion. The Supreme Court has put it this way: implicit in the right to engage in activity protected by the First Amendment is a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. In other words, the legal adoption of expressive association instrumentalizes the associational right. It must be enlisted towards some purportedly more significant end. But as political theorist George Kiptep has observed, in the real world, people find the association of value in itself. Instrumentalizing association towards outward expressive ends neglects these other goals. Expressive association also comes with a troubling corollary. Some associations are non-expressive. This category for non-expressive association obscures the fact that all society acts have expressive potential. Joining, gathering, speaking, and not speaking can all be expressive. It becomes very difficult, if not possible, if not impossible, to place this line apart from the expressive intent of the members of the group. Finally, the right of expressive association seems to marginalize the significance of a group's composition, membership, and leadership to its other expressive purposes. As the Supreme Court has asserted on multiple occasions, there can be no clear example of intrusion into the internal structure or affairs of associations and a regulation that forces a group to accept members it does not desire. Such regulation may impair the ability of the original members to express only those views that brought them together. Freedom of association, therefore, plainly presupposes a freedom not to associate. Roberts versus United States, JCs, 1984. Yet in practice, the court has often failed to honor the implications of this claim. In one of the most disturbing decisions in this area for the law, a 5-4 majority, including the 2010 decision, Christian Legal Society versus Martinez, that claims the speech expressive association simply merged into free speech analysis. The conclusion implied that the right of association raises no important First Amendment values left unaddressed by the free speech right. So too, it seems with the court's treatment of the rights of assembly and petition. Next perspective, reading the First Amendment as a whole by Bert Newborn. The 45 words of First Amendment list the 6 necessary ingredients for democratic self-government. The Establishment Clause, freedom from religion; the Free Exercise Clause, freedom of religion; the Free Speech Clause, freedom to speak your mind; the Free Press Clause, freedom to use technology to transmit speech to a large audience; freedom of assembly, freedom to join with others to advance ideas; and the right to petition government for redress of grievances, freedom to present arguments to the government. The careful order of the 6 ideas replicates the life cycle of a democratic idea, born in a free mind, protected by the 2 religious clauses, which are viewed today by the Supreme Court as protecting secular as well as religious conscience, communicated to the public by a free speaker, disseminated to a mass audience by a free press, collectively advanced by freely assembled persons, and presented to the government for adoption pursuant to petition. No other rights-bearing document in our history lists the foundational ideas of conscience, speech, press, assembly, and petition in one place, much less in the careful order imposed by the founders. Instead of treating each of the First Amendment's 6 clauses as protecting an essential ingredient of a democratic life worthy of independent elaboration, the modern Supreme Court often concentrated solely on the 10 words of the Free Speech Clause, demoting the press, assembly, and petition clauses to specialized forms of speech. The result is an underdeveloped Free Press Clause, an anemic Free Assembly Clause, and a petition clause on life support press. If the Free Press Clause were viewed not merely as a column of the Free Speech Clause, but as a freestanding grant for protection to the process of using technology to disseminate speech to a mass audience, the Supreme Court would be obliged to consider and define the role of a free press in a functional democracy. At least 3 things might change. First, the court might reconsider its refusal to grant the members of the press increased access to places like prisons that are hidden from public view. Second, the court might insulate the press from liability for merely transmitting someone else's speeches, like the immunity enjoyed by the telephone company. Finally, the court might reconsider its decision to treat huge corporate media empires as fully protected speakers. Instead, it might view them as technological conduits with a duty to provide access to weak voices as well as the strong ones. Assembly. On the current law, the Supreme Court treats exercises of freedom of assembly like picketing, demonstrating as a free speech that is abrogated with action. Thus, while the Supreme Court recognizes the abstract First Amendment rights of people to gather together on streets and in parks for meetings, speeches, parades, protest marches, picketing, and demonstrations, it also grants the police broad discretion to regulate public assembly in the name of preserving public order. Sometimes, the regulations require groups to obtain a permit in advance. Supporters of permit laws argue that they are needed to give the authorities notice of the possible need for the place of presence or to assure that competing groups do not seek to occupy the same space at the same time, risking violence. Opponents fear the local authorities will abuse the permit process to prevent unpopular persons from acting collectively to support their point of view. In an effort to minimize possible abuse, the Supreme Court bans permit laws that give local authority too much discretion about whether to permit assembly and require that when permit laws be enforced with strict equality. If a permit is granted or it is not required, public assemblies remain subject to discretionary regulations by the police in order to minimize the risk for disorder or interference with the rights of others. The Supreme Court had ruled that it is the job of the police to protect assembly from a heckler's veto. Wherever hostile response threatens to spill over into violence, inevitable pressure exists to shut down the assembly. Pressure also exists to prevent the assembly from inconveniencing non-participants through noise and interference with the free passage. Surprisingly, despite the court's effort to limit police discretion by requiring equal enforcement of precise regulations, under existing law, free assembly often exists at the mercy of the police. Witness the fate for Occupy Wall Street. anarchic exercise in free assembly that was initially tolerated but rapidly suppressed when it threatened to inconvenience too many non-participants. While the tension between free assembly and public order can never be eliminated, recognition that the First Amendment treats free assembly as a fundamental building block for a well-functioning democracy, and not merely as a disfavored form for free speech, might place greater restraint on the power of the place to regulate free assembly. Preserving a vigorous right to assemble freely is particularly important since marches, picketing, and demonstrations provide poor, less well-educated segments of the society with a potent and inexpressive method of expression that does not require verbal sophistication. Petition. Under existing law, the petition for redress of grievances clause is a dead letter. While the Supreme Court has ruled that the petition clause adds nothing to a free speech claim, the founder must have believed that the right to petition was not the same thing as the right to speak. That is why they put the two ideas in separate clauses. Or might we resuscitate the petition clause in the 21st century United States? We might invent the petition clause as an anti-gridlock device to force the legislature to consider issues that, according to the petitioner, are being swept under the rug. We might require answer to a formal petition. We might even require a formal vote. In a political system where legislators risk being insulated from the constituents, petitions might trigger the dialogue that unites them closer together. Finally, the petition clause may have untapped potential. In 1958, the Supreme Court expanded the literal text of free assembly clause to protect analogous but actual textual freedom of association. Most observers applaud this expansion of the assembly clause to cover more modern forms of democratic collective action. A similar potential for expression but analogy exists in the petition clause. As we have seen, the 6 clauses of the First Amendment track the operation of democracy, culminating in the citizens' formal interaction with the government under the petition clause. Until now, the ideal petition has been limited to presenting written arguments to the government. What if petition were expanded to include the ultimate petition to redress grievance? Voting as assembly was expanded to include association. Maybe that's where the exclusive constitutional right to vote is hiding in plain sight, just waiting to be discovered? Good question.